Boston police officer John O'Keefe was found face up in the snow on Saturday morning.
His girlfriend, Karen Reed, has been charged. She's accused of backing into him with her car and leaving him to die in a blizzard outside of a party at a Canton home.
Reed pleaded not guilty to manslaughter, motor vehicle homicide, and leaving the scene of a crash causing death.
Lawyers for the woman under arrest not only say their client is innocent, but they're alleging a cover-up.
They say there were a lot of people at the home that night, and one of them Googled how long to die in the cold hours before Reed would have known O'Keefe was missing.
First got to that scene at 6 a.m. and did not find a single piece of taillight. And then 12 hours later, boom, they found taillight everywhere.
A lot of people are talking about this. This is a small town where everyone knows everyone.
People in this town are scared of the people who are supposed to protect and serve.
Reed's parents and thousands supporting her say there's so much more to this story that doesn't add up. At C.F. McCarthy's in Canton, they laugh and embrace during a night of heavy drinking.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
The state has filed 3 oppositions making accusations against Reed and her attorneys of acting recklessly and intentionally giving a blogger confidential information to taint the investigation.
How dare the prosecution try to prohibit defense counsel from doing our jobs? How dare they ask this court to take away our First Amendment right to free speech?
The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless, and it needs to stop.
This is not a Hollywood star. This is an accused murderer getting a standing ovation as she enters the courtroom. What is going on out there?
So listen up, sir, and I'll speak slowly so you understand. My Morrissey, we ain't got no quit.
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
I've spent a lot of time thinking about John O'Keefe, his life and his death. It seems that the only thing that people can agree on in this case is that John O'Keefe was a great cop and a wonderful man. It's hard to think about the terrible fate that he suffered and the devastating impact that that loss of his life had on so many people who loved him. In a statement released by his family, John was described as a dedicated police officer, exemplary guardian, son, brother, uncle, and friend. They said after the loss of John's sister, and then her husband shortly after, John welcomed the opportunity to raise his beloved niece and nephew, and to build a home and a life around their needs. And, they said, it is heartbreaking to suddenly be talking about him in the past tense. Losing a child is something that no parent should have to go through, but to have to lose 2 is beyond tragic. John's niece and nephew suffered a tremendous loss with the passing of their mother, and then again with their father not long after that. John stepped in to give the children a loving and stable home to rebuild their lives, and on January 29th, 2022, that was taken from them as well. It's no surprise, given these circumstances, that there's so much passion surrounding the desire for justice for John O'Keefe, although the idea of what that justice looks like remains divided. We've gone deep into the extensive issues in this investigation, the inconsistent statements, and the evidence that has often raised more questions than it has provided answers. But a case can't be built only on what's done wrong. Our legal system is set up on the principle that every person accused of any crime is considered innocent unless proven guilty. It's up to the prosecution to prove to the jury that the accused is guilty beyond a reasonable doubt. This burden of proof is a much higher legal standard than what is required in a civil case, for example. For a criminal trial, the jury has to believe a defendant is almost certainly guilty. This is a very important distinction when looking at the case against Karen Reed. The prosecution will present the evidence that they have against her, and the defense will poke holes in each piece of evidence, and also present their own third-party culpability defense. But this doesn't mean that both sides tell their theory of what they think happened to the jury, and the jury picks which one they think makes the most sense. The burden of proof lies completely on the Commonwealth. The defense isn't even required to put on a case or ever call a witness. Karen Reed does not have to prove that she didn't do it. The Commonwealth has to prove that she did. Nobody witnessed Karen Read hit John O'Keefe. And contrary to what was originally leaked to the media, there's also no video surveillance proving her guilt. All of the evidence against Karen Read is circumstantial, which is pretty common in criminal trials. Circumstantial cases rely on the evidence presented to show a series of events and circumstances that can only be explained rationally if the defendant is guilty. But if there is any other reasonable explanation consistent with Karen's innocence, any other rational supposition, then Karen must be found not guilty. Since we know there's no direct evidence that proves Karen's guilt, the evidence that will be presented against her during the trial will serve to support the assertions of the Commonwealth. They will lay out their theory and give evidence that they say supports that theory. The defense has their own version of events that they offer to be true, backed by different evidence, interpretations of evidence, and expert opinions. Over the last 2 years, we've watched as both sides have battled it out in court over some of this evidence, and this week we are going to take a closer look.
Prosecutors now say that they have DNA evidence that showed Read's vehicle likely hit John O'Keefe.
Yeah, this is the fourth opposition the Commonwealth has filed just within the past week, and in it does describe DNA evidence in the form of hair and from the beverage cup John O'Keefe was holding.
As the high-profile murder case gets closer to trial, prosecutors filing new court documents that allege forensic experts found DNA evidence from the victim himself, John O'Keefe, on Karen Read's vehicle. The records state a small apparent hair was noted on the rear passenger side quarter panel. Pieces of an apparent cocktail-style glass, consistent with that the victim was seen on video exiting the waterfall within his right hand, was also noted on the rear bumper.
Let's go through the physical evidence. Physical evidence is any tangible object that can connect a suspect to a crime scene. And in the world of criminal law, physical evidence is king. Attorney Justin McShane says, quote, "Physical evidence exists independent of the hopes and wishes of anyone. This is why it is so very important for physical evidence to be discovered, not contaminated, and properly analyzed." End quote. DNA is a type of physical evidence and in many cases can be the determining factor in why a juror votes to convict someone. On the other hand, it can also be what sets someone free. According to the National Registry of Exonerations, there are currently 596 cases in which post-conviction DNA testing, analysis, or interpretation was conducted, and the results were a factor in establishing the factual basis of exoneration. But unfortunately, not every case that has DNA collected is an easy, slam-dunk answer to the proverbial whodunit. There are a lot of factors involved, and don't we already know that nothing in this case is that simple? One piece of evidence that has been at the center of controversy is what may or may not be a human hair that was found on the back of Karen Read's SUV. Hair is commonly found at crime scenes, but hair shafts that don't have a root attached present some challenges when it comes to forensic testing. Think back to 8th grade biology, where every science lab had a poster on the wall of the twisty ladder that illustrated DNA structure. There are the two long, spiraling strands that make up each side, and they're connected by a repeating pattern of multicolored ladder rungs all the way up. The order in which everything is arranged is unique to every person, which is why DNA profiles can be used to identify someone with certainty if a lab is able to get enough of that DNA profile. This ladder is nuclear DNA, and it comes from the nucleus of a cell. It has all the genetic information that makes you who you are. And ideally, this is what's desired for forensic testing. However, if a hair is missing the root, it's not always possible to get nuclear DNA from the hair. The next option is mitochondrial DNA. Instead of that ladder shape, this is genetic code that forms a circular shape, and it's limited to just the genetic information that's inherited from the subject's mother. While this doesn't give as much genetic coding as nuclear DNA, it still gives some, and it's able to determine if it's a human hair or not. So let's break this down. Here are the issues with the apparent hair. Number 1, the prosecution said that the hair was forensically confirmed to be a human hair.
As it pertains to the hair, the history of that hair is somewhat tortured
The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. They filed motions with the following phraseology. Quote, "The hair has been forensically confirmed to be a human hair," end quote. Not once, not twice, 4 separate times, and the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious, and it's intentional.
To determine if this is deceptive or not, we need to break this down a little. What does it mean to have a hair forensically confirmed as human? Forensically is defined as using forensic science, and forensic science is the application of science principles and methods to support legal decision-making matters. So if something is forensically confirmed, it would mean that reliable scientific methods were used to confirm that the hair was human. So if that's what happened, then it wouldn't be deceptive, right? Attorney Alan Jackson continues.
I expect that Mr. Lally will say something along the lines of, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination. On the exact same issue, and it's not like a generalized proficiency exam, it's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it.
Microscopic hair analysis has been used in labs by law enforcement and FBI for decades. Microscopic hair comparison analysis is comparing a hair, for example, from a crime scene, to another sample for identification purposes. Now, this has been pretty controversial as science has advanced because it has been determined to be completely unreliable. In fact, according to the National Association of Criminal Defense Lawyers, the FBI estimates that approximately 21,000 cases involving microscopic hair analysis will have to be re-examined. There are, however, certain distinguishable characteristics of human hairs that are visible under a microscope. For example, human hairs don't usually change color within a short distance unless there's dye or bleach. And another example is the medulla in human hair is usually less than 1/3 of the overall diameter of the hair shaft, but in animals it is usually a little bit more. And finally, the scale pattern of human hair is different than it is in animals. Now, these are very specific things to look for, and if the person who checked these things didn't pass a proficiency exam, that could be a big problem. But microscopic hair analysis isn't the only way to determine if hair is human. There's always DNA testing. The hair that was found on the back of Karen's car was submitted for DNA testing, but no human DNA was found. Now, this testing was looking for that ladder-style DNA that we mentioned earlier, but the lab results say there isn't any, so no STR analysis was performed. This is Lally's explanation of that.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair. I believe what has just been stated is a complete misrepresentation of what that DNA testing report says. So what the DNA testing report says is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis, the second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA typically in typical DNA testing from the actual strand of hair, which you're using the root end in the hope that there are some residual skin cells that are left from that root end in order to conduct the testing. So when they get to the second step in this particular analysis, the quantitation, there is an insufficient amount of any DNA to be able to generate a sample or a DNA profile from. That's what no human DNA detected means, which I'm sure counsel is well aware of in its representations to the court to the contrary. So the STR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step. So the findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item.
So the prosecution has had access to the hair at the time of this hearing for about a year and a half. They had a microscopic examination done by someone who isn't qualified, and then did DNA testing where no human DNA was detected, but have said repeatedly that the hair has been forensically confirmed. Now, to be clear, this doesn't mean that the hair definitely isn't human or that it definitely isn't John's, but what it does mean is that it is one more major issue with the state's case, and it offers up more reasonable doubt. The next step in the process of confirming it would be to have the lab test it for mitochondrial DNA, which is that circular-shaped DNA that we talked about earlier that isn't quite as precise, but it's still able to give some genetic information. The problem with this is that doing the mitochondrial DNA testing will destroy the hair, and the defense attorney, Jackson, wants to be able to have that microscopic testing done by a separate lab before the mitochondrial testing is done, or else he'll never have the chance to do it since the hair will be destroyed.
So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which would, as Mr. Lally indicates, he's smart enough to know. The lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. My position is it should not be destructively tested, certainly not by the Commonwealth. I understand, I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind, out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically, make their own determinations. At that point, Mr. Lally, myself, we can agree, if in fact the results are satisfactory, to have it exhaustively tested, but certainly not now. Not after this, as I said, tortured history of this item.
Assistant DA Lally responds to that.
So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there is nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their observation policy and because of the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson, I just want to know the answer to this question. Did they give you a timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
At the end of the day, all we're asking for is to have the item reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lowley's response, and I understand why he's responding this way, well, there was no deception here, we weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes, it looked like a hair. Why didn't they say that? Why didn't they say, it looks like a hair, as established by our expert who failed her proficiency examination? That would have been a truthful statement. But the statement that they've repeated over and over and over to this court in papers and in affidavits under oath, under penalty of perjury, is the hair has been forensically confirmed. There is no, you can't word salad your way out of that. Forensically confirmed means it's been DNA tested to confirm forensically and scientifically that it is a hair. Then they turn around and try to confirm it forensically, and there is no human DNA detected. I understand that the short tandem repeat testing, the mitochondrial testing, has not been done yet. That's their 11th hour sort of Hail Mary to try to cover themselves for what they've already done, which is to basically defraud the court. And not one, but two, but three, but four different filings. 3 in front of this court, 1 in front of the Court of Appeal. It just doesn't pass the smell test. What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road. We want access to that item so that we can confirm whether or not it's even microscopically been properly analyzed. That's all we're asking.
So fast forward now to this week. Lally said in a hearing on Thursday that Bodie Labs has the sample and he has talked to them multiple times over the last few days. Here's what he said.
I've spoken to the lab a few times over the last week or so, including this morning. So they were able to stay late last night and finish the generating, to see if they could generate a mitochondrial DNA profile for the hair sample. I was informed this morning that they were able to generate a partial profile. They're still in the process of seeing if a full profile can be generated, but they've begun the process of generating a profile from the sample from Mr. O'Keefe. As far as I'm a little unclear, and I responded with some questions just for clarification purposes, because I'm a little unclear of whether or not a partial profile would be something they could do a comparison with in regard to the mtDNA. And then I'm also inquiring as to, so initially what I've been told is that if they were not able to generate a profile, I would have a report on that by the end of next week, and that would essentially be the end of it. However, given this development, I'm not sure, other than they indicated that any sort of report regarding a comparison would likely be sometime after April 16th. And then obviously I asked for clarification, and I'm still waiting that as far as what after April 16th means, as far as are we talking about, you know, the week following or a month later, or what the situation is. So unfortunately I don't have a ton of clarity, but at least I'm able to tell the court that they were able to generate at least a partial profile from the hair sample.
All right, so trial starts a week from Tuesday. I would entertain a motion to exclude the DNA. All right, so let's move on to what we have here.
So here we are a week and a half before trial, and no DNA from the supposed hair is available. Now, keep in mind, this is one of the biggest pieces of evidence that we've heard that is supposed to link John O'Keefe to the car. But as of 12 days before the trial, after more than 2 years of dealing with this, there's still no DNA available from the apparent hair. Now, court documents say that trace analysis and forensic testing have found Officer John O'Keefe's DNA on the taillight and on microscopic pieces of red and clear plastic that were found in his clothing. So, for DNA to be present on microscopic pieces of anything found in someone's clothing isn't surprising. John's DNA will be all over his clothing, so that's not really a big deal in this case. The microscopic pieces of taillight themselves, however, have been a part of the debate.
Reed's defense held up pictures of what they describe as O'Keefe's clothing on the floor of the hospital where he was pronounced dead to suggest sloppy evidence collection.
Now, I expect that the Commonwealth will argue 2 points, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and 2, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed. He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2:30 a.m., Jennifer McCabe Googling how long to die in cold at 2:27 a.m., and then 3 minutes later, Brian Lawfern driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet you see a pile of John O'Keefe's clothing, unattended, sloppily thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing was not submitted to the lab, Your Honor, until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks.
So if the chain of custody is in question and the lead investigator who is allegedly conflicted had custody of the clothes and was in possession of them for weeks before sending them to be tested, will that impact the evidentiary value of what the prosecution is presenting as evidence? Lally responds.
Again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros, that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as there is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence as far as, I guess now it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing.
So here we are, yet again, with two totally different versions of what the evidence means and what matters. The clothes that Attorney Yannetti mentioned that were piled on the hospital floor have sparked some controversy as well. We know that according to surveillance video from the bar that night, John was wearing jeans, a hoodie that was dark gray on the arms and the hood and light gray everywhere else, Nike sneakers, a baseball cap, and there appears to be a belt on his jeans. When John is found, reports say that he was wearing two shirts, the gray long sleeve shirt and an orange t-shirt, jeans, and one sneaker. The defense requested the ability to inspect and independently test the actual items of John's clothing, and in those papers they state that John's hat is not listed in the evidence log, but it was photographed as having been recovered on February 3rd. The February 3rd collection date raises some questions. Where was the hat recovered from? It seems odd that they would miss it during the multiple searches at Fairview Road, and we know that the 3rd is the day that Trooper Proctor and Trooper Evan Brandt went to John's home and took pictures of his car and the garage doors. Again, it's another question that will have to be answered at trial. There's also no mention of his socks or belt. With the sloppiness of the investigation, we aren't sure if things are missing from paperwork or missing from evidence, or if it was ever even recovered. John's other shoe was found by the CERT team during the second search on January 29th, after, quote, digging through the still falling snow, end quote. Though the details of this are unclear. The first search involved a blower that they used to melt the snow, which allowed them to find multiple pieces of broken cocktail glass, but not enough to find a shoe or the red taillight pieces. This is another question that will have to be explained at trial. There will also be questions about the clothing that he had on and the injuries to his arm. Injuries that John suffered and the damage to the car are probably the most crucial and widely debated pieces of evidence as well. Now, before we get too deep into the correlation between the car and John's injuries, I want to first take a look at one of the defense's theories that has set the internet on fire.
Second undisputed fact. When John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal? Which is exactly what they are. Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body if someone is rolled under a car or rolled in gravel because of the car? What about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. What about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own experts say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Alberts? Which is exactly where Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts' house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert.
That was a huge statement, and it's part of the core of the defense's theory. Now, during this hearing, the defense argued their motion regarding Canton Animal Control and Canton Town Clerk records. The attorney for Brian Albert stated in open court and in filings that Chloe had no history of attacking human beings. He said the reason that she was rehomed was because of an incident between two dogs. The attorney states, quote, The defense is asking the reader to conclude that the dog in question has a history of attacking human beings, and that it was sent away because it was violent towards people. As with other defense assertions, this is not true." End quote. The defense says that after receiving and viewing the records from Canton Animal Control, however, all parties are aware that that statement was a lie.
You have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, but that information was kept from you.
According to court documents, Chloe attacked two different people. One individual was bitten on the arms, neck, and leg, and the other was bitten on the left hand. No reference to Brian Albert's German Shepherd Chloe was ever made in any of the police reports turned over in connection with the case. Information regarding this skin-piercing incident and Brian Albert's decision to rehome Chloe was discovered by defense investigators after interviewing witnesses in the town clerk's office. The Commonwealth says that in efforts to disprove the defendant's allegations, they have submitted evidence to a veterinary forensic laboratory that concluded that there was no canine DNA associated with the swabs taken from the victim's clothing in the areas of the victim's injuries. So we hear defense attorney Alan Jackson say that if tissue samples are taken from John O'Keefe's wounds, he believes that they will find canine DNA. Court documents reveal that in an effort to disprove the allegations from the defense, the crime lab prepared 2 additional samples from the victim's outer clothing, specifically the right arm sleeve of his long-sleeve shirt, to test for the presence of any non-human DNA. Since Massachusetts State Police doesn't have the ability to test for non-human DNA, the Commonwealth contacted the Veterinary Forensic Genetics Laboratory at UC Davis to perform the testing. Those swabs of the clothes came back with no canine DNA. That didn't end the debate, though. The samples were taken from John's clothing, but communication from ADA Lally said specifically that there were never any tissue samples taken from John's right arm. So, the debate continues on. Some people are convinced that the injuries came from a fight and from Chloe the German Shepherd. Some people are convinced that John's injuries came from Karen's car. But what does the evidence say? According to court documents, the damage to Karen's car was pretty minimal aside from the taillight. The car was towed from Karen's parents' house to the Canton Police Department. Now, you'll remember that Canton PD doesn't have jurisdiction over this investigation, and since Kevin Albert is an officer for Canton, that would be a conflict. But that's where it was taken, and Massachusetts State Police Crime Scene Services Section, a crime lab chemist, and Trooper Joseph Paul of Massachusetts State Police Collision Analysis and Reconstruction Section all responded to the department. They observed fragments of broken glass on the rear bumper of the vehicle. The rear right passenger side taillight was shattered and pieces were missing from the red and clear areas. On the right side of the rear tailgate, a deep scratch and a minor dent were observed. On the right side of the rear bumper, above a small red light, 2 scratches were observed, as well as one area where the paint was chipped off. One thing that we've heard brought up multiple times in this investigation is that cocktail glass.
Damages to the right rear corner panel of the defendant's vehicle. Embedded within the bumper to that vehicle is pieces of cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
When I think about glass being embedded in the bumper, I think about how hard you would have to hit something in order for that to happen. I've considered the possibility that maybe John threw his glass at the bumper, especially if they were arguing at the time. But it seems hard to understand how there would have been enough force to hit John so hard and for him to hang on to the glass so that it gets embedded in the bumper, especially since that kind of impact seems like it would have caused damage to John's legs where there wasn't any. And while Lally says that Karen definitely made impact with Officer John O'Keefe by backing her car up and running over him, Attorney Alan Jackson says that that's not what the evidence shows.
The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car. Period, full stop. That's their independent expert, not ours.
So once again, 2 totally different versions of what's happening. We haven't seen the federal investigators' report, but if independent investigators do in fact say that the injuries that John sustained and the damage to the car don't add up, that's going to be really hard for the prosecution to explain to a jury. So what do the experts have to say about this? We're getting really close to trial, and we still have some important things to cover. Next week, I talk to Dr. Kenneth Kinsey and get his expert opinion. Dr. Kinsey has extensive experience in crime scene investigation, processing, and reconstruction. His impressive resume and skill landed him on the stand as the star witness in the trial against Alec Murdaugh. We will also dive into the allegations that the prosecution has made against the defense, including accusing them of a conspiracy to leak and spread information in hopes of having the trial dismissed. I mentioned a statistic earlier from the National Registry of Exonerations. And before we close this episode, I want to mention one more. At the time of this recording, there are currently 3,494 exonerations on the registry, for a total of almost 32,000 years lost. 32,000 years that were stolen from innocent defendants who were convicted on evidence that shouldn't have been enough. They were robbed of their freedom, their liberty, precious time that they'll never get back, all while the person who is responsible remained free. People lost their husbands, wives, sisters, brothers, friends. People lost their children for years due to wrongful convictions. With that in mind, isn't it worth taking a closer look at all the evidence with an open mind? Isn't it worth critically thinking and analyzing everything? Justice isn't punishment for wrongdoings. Justice is ensuring that everyone is treated in a way that's equal and fair, no matter what you may think happened. That includes the families, the witnesses, and the defendant. Isn't that what we all want? What if it was your family member? Or what if it was you? My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.